Hi, I'm Tristan, and this is Thinking About Politics. So today, I'm kind of like sounding the alarm bells a little bit because Republicans, especially the Christian nationalist ones, are going to come after contraceptives and birth control. Yeah, make no mistake. After the Supreme Court's recent decision in Dobbs v. Jackson, which annihilated the right of people to choose to terminate a pregnancy, at least before a certain point, all sorts of rights that we sort of thought were settled are now maybe at risk and will go away unless action is taken. Yeah, unless we all get involved. In places like Missouri and Louisiana, Republicans in those state legislatures are already targeting certain types of birth control. Let me explain. As long as people have been knocking boots, people have also been trying to prevent unwanted pregnancies, going back thousands of years. In the 19th century, you saw the rise of new scientific forms of birth control that hit the open market. New information about the science of family planning and birth control became widely available. And perhaps not surprisingly, that also precipitated a spate of state laws restricting access to birth control. In fact, in 1873, a federal law known as the Comstock Laws also prevented movement of contraceptives by mail or dissemination of information about birth control and family planning. The justification for these laws sounds kind of out of place today. As one Massachusetts Supreme Judicial Court decision put it, manifestly, laws restricting birth control or information about family planning are designed to promote the public morals and, in a broad sense, the public health and safety. Their plain purpose is to protect purity, to preserve chastity, to encourage continence and self-restraint, to defend the sanctity of the home, and thus to engender in the state and nation a virile and virtuous race of men and women. The subject matter is well within the most obvious and necessary branches of the police power of the state. So, can the government prevent contraceptives on the basis of, moral purity and sexual hygiene? Before Griswold v. Connecticut, yeah, the answer was yes. And you had to wait till 1965 for the Griswold decision. That's give or take 100 years since these laws really became in vogue. So what changed in Griswold? Well, Justice Douglas is basing his decision on a reading of the 14th Amendment, which is the most important amendment we have. See, the Bill of Rights might prevent Congress or the federal government from doing certain things, but it really doesn't bar the states from too much. Like how the First Amendment says Congress shall make no law establishing religion? Well, the Massachusetts state legislature certainly could. And in fact, well into the 1800s, state taxes went to go pay congregational ministers. All in an effort to promote regular church attendance. Wrap your head around that. The 14th Amendment actually puts prohibitions on states. It reads in part, "No state shall make or enforce any law which shall deprive any person of life, liberty, or property without due process of law." So here Justice Douglas is looking at a state law in Connecticut that prevents married couples from accessing contraceptives or medical advice about birth control. So the question is, does the government really have an interest in protecting things like the purity and chastity of the public that overrides a married couple's decisions about their intimacy? For many people, myself included, there's an immediate intuition that the answer must be no, right? I don't care who you think you are or what you have to say about the separation of powers, but a bunch of sycophants who go ahead and get themselves elected to the state legislature, I don't think they should be practicing medicine, and I don't think that they're qualified to make any sort of moral judgment about birth control or how people use contraceptives, absent some deep and compelling reasoning, of which Connecticut had none. On the other hand, let's steel man up the other side here for a second. There's a couple points we can't really debate. One is that the Constitution does not expressly say that people have a right to contraceptives or birth control. It doesn't say that. Nor does it say in express terms people have a right to privacy or define what that right is. If you find it in there, it's an implied right. So there's an argument that at least goes like this. The liberty that married couples are being deprived in Connecticut is just the liberty to use birth control or contraceptives, which is not a right protected by the Constitution. Therefore, the process that's in place, meaning a state legislature being duly elected and passing a law in the normal course of business is the process due. Therefore, the due process clause of the 14th Amendment is not violated, no matter how much we actually disagree with this law. The state legislative process is enough to ensure that this right is not arbitrarily denied. And it's a good question we should ask. On what grounds can a court strike down the laws passed by a legislature when legislative power is given to that branch, and when the law that they pass doesn't expressly contradict a constitutional guarantee? Justice Douglas and the majority thread the needle this way. We do not sit as a super legislature to determine the wisdom, need, and propriety of laws that touch economic problems, business affairs, or social conditions. This law, however, operates directly on an intimate relation of husband and wife, and their physician's role in one aspect of that relationship. The present case, then, concerns a relationship lying within a zone of privacy created by several fundamental constitutional guarantees. And it concerns a law in which forbidding the use of contraceptives rather than regulating their manufacture or sale seeks to achieve its goal by means of having maximum destructive impact upon that relationship. Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. We deal with a right of privacy that is older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together, for better or worse, hopefully enduring, and intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. Yet, it is an association for as noble a purpose as any involved in our prior decisions. So the liberty at issue here for Justice Douglas is the privacy between married people. Marriage is an association of people. The First Amendment protects the right to peacefully assemble, therefore it protects associations. And, there's a logic to this when you really think about it. There are different guarantees in the Constitution that kind of carve out different spheres of privacy. Take, for example, the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Courts have repeatedly held that this right creates a zone of privacy, a right of privacy. And you can kind of do the same thing with other rights. So you say the First Amendment, right of assembly, creates a zone of privacy. The right of freedom of expression of religion creates a zone of privacy around the decision of what religion one chooses to adhere to. The Third Amendment bars the quartering of soldiers, creating more right of privacy in one's home. The Fifth Amendment contains a right against self-incrimination, which creates a right of privacy over one's incriminating acts or information. You don't have to share those with the government. Justice Douglas writes, specific guarantees in the Bill of Rights have penumbras, formed by emanations from those guarantees that help give them life and substance. Various guarantees create zones of privacy. So in one way you could read Justice Douglas's decision as saying something like, there's a right of privacy somewhere in the Bill of Rights, it's fuzzy, but it's in there. Because it's in there, it's covered under the Liberty Clause of the 14th Amendment, therefore, the state's got to meet some sort of higher burden, some sort of real justification for this law then. But I think it's also kind of interesting to note that three justices, signed on to a concurring opinion just to say that they do not believe the liberty guarantee in the 14th Amendment is constrained by the first 8 amendments of the Bill of Rights. They do not read the 14th Amendment as just saying the first 10 amendments in the Bill, or the first 8 amendments in the Bill of Rights are hereby incorporated. They read it as saying liberty in a real fundamental sense. And I mean, that idea that married couples can make their own decisions and the fact that birth control has been used for thousands of years kind of suggests that, yeah, that's a liberty that's, protected. That is not something that the government can lightly tread upon. Some of you might be thinking at this point, hey, what about single people? Well, single people aren't covered in the Griswold decision. There were still laws on the books in different states prohibiting the sale of contraceptives to unmarried single people. In 1972, the court decided Einstedt v. Baird. where a BU professor who was handing out contraceptives and information about contraceptives was arrested under a state law and fined. The state tried to argue in different times that the prohibition against contraceptives was really a public safety and public health measure. They wanted to prevent sort of dangerous items of contraceptives being just given to the public freely. But the court wasn't really buying that. They thought that the law was a prohibition on contraceptives per se, that this was kind of a violation of Griswold, even for single people. Einstein really says that the right of privacy that the court was talking about in Griswold doesn't belong to a married couple, it belongs to individuals. Whatever the rights of the individual to access to contraceptives may be, the rights must be the same for unmarried and the married alike. If under Griswold the distribution of contraceptives to married persons cannot be prohibited, a ban on distribution to unmarried persons would equally be impermissible. It is true that in Griswold the right of privacy in question adhered to the marital relationship, yet the marital couple is not an independent entity with a mind or heart of its own, but an association of two individuals, each with a separate intellectual and emotional makeup. If the right of privacy means anything, it means the right of the individual, married or single, to be free from unwarranted government intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. So the right to use contraceptives boils down to an individual right of privacy. The fact that individuals are allowed to make that choice for themselves, free from government intrusion. But after Dobbs v. Jackson, we have to ask, is this really the case anymore? I mean, compare Einstein's understanding of the right of privacy, meaning the freedom to decide whether or not to beget a child, with Sam Alito's opinion in Dobbs. In interpreting what is meant by the 14th Amendment's reference to liberty, we must guard against the natural human tendency to confuse what that amendment protects with our own ardent views about what liberty that Americans should enjoy. With regards to the right of privacy, the court did not claim that this broadly framed right is absolute, and no such claim would be plausible. While individuals are certainly free to think and say what they wish about existence, meaning, the universe, the mystery of human life, they are not always free to act in accordance with those thoughts. License to act based on such beliefs may correspond to one of the many understandings of liberty, but it is certainly not ordered liberty. You might not think that using contraceptives and having premarital sex is such a big deal, but Sam Alito is telling us that such rights are not, I repeat, are not guaranteed under the Constitution. Anyway, look, we harp a lot on this idea of right of privacy. But as one of the dissenters in Griswold makes clear, and it has a really good point, privacy is a term that can expand and contract. It can mean a lot of different things to a lot of different people. It's a squishy term. So is the liberty we're talking about just really about privacy? Or is it really about the right of private action? The ability to make one's own decision about how to live one's life, about whether or not one should engage in premarital sex, about whether or not one should use contraceptives? Or is this about controlling people and trying to make those moral judgments? Is this about trying to enforce one small, narrow view of the world on people? Or is this about allowing people to be nonconformists? Truth of the matter is that the current crop of conservative legal theorists and Republicans do not have much respect for the right of the individual to be a nonconformist. So maybe it's time to reframe this right of privacy as to something like a right of having a private sphere of action, having a private ability to understand the world, to make sense of the world, and then to act upon it. Contrary to what Justice Alito says, the ability to think about life, the ability to consider the big questions doesn't really seem to mean a lot to me, unless you can act on them in some form or fashion. So, and I just wonder, if people are going to wake up to what's going on and how, there's this Republican effort to strip people of their rights in the name of enforcing some norm, some sort of like Christian national norm. I wonder if people who are voting Republican in 2022 are going to wake up at some point in a state that doesn't allow condoms or something ridiculous like that and sort of have to scratch their head and figure out what's going on. Sure hope not, but anyway. Hey, if you made it this far, think about giving us a like or a subscribe. That'd be awful nice. But, you've been great. I hope to see you again next time. Until then,
You keep cool. I ain't
keep
got
thinking.
time to kiss you now. I'm busy with